Good morning and welcome everyone. It's 9 o'clock, so we'll go ahead and get started. Thank you for joining us today. As a reminder, this session will be recorded, so if everyone will go ahead and turn off their microphones and cameras, that will be beneficial. If you have any questions, please post those in the chat. Before we begin, I wanted to thank everyone for your time last month to discuss everything artificial intelligence, from the range of fascinating possibilities to the potential challenges ahead and how best to limit your liability. Since this webinar covers April's educational topic, I'll give everybody a sneak peek into the topics we'll cover when we meet in May. As many of you know, our focus this year is on management training. We've recently implemented collaborative management meetings, basically a 15-minute meeting once per quarter to promote internal communication, as well as to provide a forum for managers to proactively share any current or looming concerns. We've had great success with the program so far and are eager to bring the benefits to more of you. We'll also discuss our focus trainings such as discipline and discharge and harassment prevention. Now for our main event, I'd like to introduce Keith Hammond of the Hammond Law Center. As many of you know, we partner with Keith to answer many of your employment-related questions, and at least once a year, we work with Keith to provide overall employment law updates. So without further ado, Keith, I'll turn it over to you.
Great. Thank you so much, Myra. And I'd just like to start by thanking Myra and everybody at AAG. We've been doing these updates for many years now. And previously, we held these in person. We've done them online for the last several years. It has worked out well. I will say that the one thing I do miss about in-person presentations is that we tend not to get as many questions when we're online. If you would like to ask a question, please feel free at any time. There is a comment box or a chat box in the upper right corner of your screen where you can type in a message, and I will try to monitor as we go through the presentation, and Luann may interrupt me if she notices that I have a question pending that I haven't answered. So with no further ado, let me share my screen here. Bear with me for just a second here. And hopefully now everybody can see the presentation up on the screen. Well, welcome everybody. Let me just dive right into it. You know, the reason that we're here today, as we are every year, is to go over what we've seen in the world of employment law recently, since the last time we met, as well as what to expect in the future. And these employment law updates are generally based on one or more of a few different things. I always say that these presentations are not political, but we do discuss government an awful lot, because how are employment laws made? Well, typically laws are passed by Congress or a state legislature and signed into law by the president or a governor. And as you can imagine, when the legislative body is either split, like the current Congress is, or belongs to a different political party than the executive branch, not a lot of legislation gets passed. And we saw this throughout the Obama administration. We saw this in the second half of the Trump administration. We are moving into that phase now in the Biden administration, where Congress is split. The House is controlled by the Republicans. The Senate is controlled by the Democrats. There's a Democrat in the White House. Do I anticipate that we will see a ton of employment-related legislation coming out in the next 2 years? Probably not. We did have some legislation, though, that came through really at the last minute before the new Congress was sworn in January of this year, and we'll talk about that a little bit. In Florida, of course, the governor's mansion is occupied by the same party as the legislature. To date, however, they really have not passed a whole lot of workplace legislation. I know the last time we met, we talked about the Stop Woke Act. We talked about the restrictions on training that can be done in diversity, equity, and inclusion type training. I'm not going to rehash those because we've already covered them. What we will discuss are some of the things that we've seen this year that might not be as obvious as applying to workplaces. We're going to also talk about some other state legislative updates that might have an impact on Florida employers, particularly ones that have multi-state operations or that allow employees to work remotely from anywhere that they choose. The other way, though, that employment laws tend to change would be through executive agencies, meaning agencies that report to the president, agencies that report to the governor here in Florida. And typically the agencies that are the most active in setting forth new rules or regulations would be the Federal National Labor Relations Board, the United States Equal Employment Opportunity Commission, and everybody's friend, yours and mine, the Department of Labor's Wage and Hour Division. We'll talk about what those agencies are up to and some of their rulings since the last time we met. And then finally, we'll end by discussing what those agencies' enforcement priorities are. They are very public about what their enforcement priorities are. You can find them online. Usually the top level lawyer, the general counsel of each one of those agencies, will issue a enforcement priority memo internally, but it's still a public document at the beginning of each year. So we'll discuss what it is that you should be looking out for, or whether you are in an industry that's being targeted for an enforcement priority by one of those agencies. So let's dive right in and start with the federal legislative update. If there's one topic that I would guess most, if not all of you, have heard at least something about in the mainstream news media, not legal news, but just normal news, it would be the discussion regarding a federal prohibition on non-compete agreements. And there are two somewhat competing proposals that are going through the government right now. The first is the Federal Trade Commission, which is an executive agency. It is not Congress. It is an agency that reports up to the president, recently issued a proposed rule regarding this subject. Additionally, within Congress, in both houses, in fact, in both the Senate and the House, there is a bipartisan bill sponsored by both a Democrat and a Republican called the Workforce Mobility Act of 2023, which would have a similar impact. President Biden has indicated that he would sign that act if it passes both houses of Congress. So we'll discuss what the differences are between the two. If you have not heard about the Federal Trade Commission's rule regarding non-compete agreements, here is what you need to know. Last year, 2022, in fact, frankly, I think it was late 2021, President Biden issued a directive to the Federal Trade Commission to take a look at implementing a rule that would ban non-compete clauses nationwide. And it took more than a year for the Federal Trade Commission to actually act upon this directive. The reason being that there were vacancies on the commission itself that had to be filled, and that frankly took about the entirety of the year. How did we get to where we are right now? Well, currently, state law, not federal law, governs non-compete agreements. And most, if not all, state legislatures within the last 30 or so years have passed legislation regarding whether non-competes are enforceable in their jurisdictions or not. You may know that California has banned non-compete agreements. You cannot be a party to a non-compete in California, except in very limited circumstances, show business being one of them. But overall, you cannot be barred from going to work for a competitor. You can be prohibited by contract from soliciting customers, from soliciting employees, or for breaching trade secret laws or confidentiality provisions in agreements like that. California is probably the most pro-employee state when it comes to non-competes. Florida is probably the most pro-employer state when it comes to non-compete agreements. Currently, non-compete agreements in the state of Florida are enforceable so long as they are reasonable in geographic scope, in temporal scope, meaning the duration of the non-compete restriction, as long as the employer has some legitimate business interest to protect with the non-compete, such as the protection of trade secrets, the protection of goodwill. There are a list of 5 different things in the statute itself. Specialized or extraordinary training is another one that's commonly relied upon. But Florida is if not the most, it's close to the most pro-employer state when it comes to enforcing non-compete agreements. For those of you that have operations in Florida and Georgia, you might recall that a couple of years ago, Georgia changed its non-compete statute to make it a little more difficult for employers to enforce there. And that led to instances where there'd be a race to the courthouse. An employer would rush to a Florida courthouse to seek an injunction. A Georgia employee would rush to the courthouse to seek the agreement being declared null and void. But anyway, the federal government, up until now, has not played a role in the enforceability of non-compete agreements. Here is what the Federal Trade Commission proposed on January 5th of this year. Now, mind you, this is just a proposal. A proposed rule is not a final rule. This is not currently the state of the law, but we suspect this is what the state of the law will be in the not too distant future. Number one, the Federal Trade Commission's proposed rule is to rescind all existing non-compete agreements no later than the rule's compliance date, which as of now is not yet determined. I'll talk a little bit more about that on the next slide. Additionally, the proposed rule, if it goes into effect the way it's currently written, requires employers to provide notice to current and former workers that the non-compete clauses are no longer in effect. Well, what do we mean by former workers? Do we have to go back for the last 5 years? No, the answer is, in the proposed rule anyway, it's any employee who left within the last 6 months would be entitled to notice that if they signed a non-compete agreement, that non-compete is no longer in effect. So what is the status of this proposed rule? Well, by law, anytime an agency proposes a new rule, such as this one, it must provide the public with a 60-day period in which to submit comments regarding the proposed rule. To date, mind you, this rule went into or was only published back in January. There have been more than 12,000 public comments that have been received. And more than 100 business groups have asked for an additional 60 days in which to comment. Some of the comments are very lengthy. They're written like legal briefs. Some are very short. In fact, there's a website called regulations.gov in which you can find any proposed agency notice and submit a comment online. So many of the comments take that format and are relatively short and to the point. Theoretically, the Federal Trade Commission could implement a final rule any time now. Although those business groups have requested an additional 60 days, the Federal Trade Commission does not have to grant that request. It could simply issue or promulgate a final rule by publishing it in the Federal Register, that's the government's official publication forum, at which time the effective date of that rule would be announced. Now, because this rule would have such an economical impact, the effective date cannot be immediate. Again, by law, the effective date cannot be any sooner than 60 days after the rule is published in the Federal Register. So, with that said, everybody will have at least 60 days notice before having to notify employees of the ineffectiveness of those non-compete agreements. If the rule goes into effect as it was proposed. Now, granted, the Federal Trade Commission could also revise the rule before it goes into effect. And we don't have a crystal ball. Unfortunately, we can't predict exactly what the Federal Trade Commission would do. But if I were a gambling person, I would probably put my money on the rule being finalized pretty close to the format in which it was proposed. Which is, of course, the complete ban. In most circumstances, I think we'll talk about exceptions in just a second here, but also the biggie in my mind is notifying all the employees that their non-competes are no longer effective. So in addition to the prohibition on non-compete agreements, the Federal Trade Commission has also addressed whether other clauses like a non-solicitation clause or a non-disclosure provision would be prohibited. The answer is generally no, unless those clauses have the effect of operating as a non-compete. And one of the examples that they gave would be a non-disclosure agreement that's written so broadly that it effectively precludes the worker from working in the same field after the conclusion of the worker's employment with that employer. Another one is a contractual term between an employer and the worker that requires the worker to pay the employer or a third party for training costs if the worker's employment terminates within a specified period, where the required payment is not reasonably related to the costs the employer incurred for training the worker. I know that many of us have these types of arrangements where they agree with the employee that the employer will front the cost of training, but if the employee leaves within a certain amount of time, the employee has to pay back some amount of money, whether it's a liquidated damage, meaning one that has been agreed upon by the parties ahead of time, or whether it's the actual cost of training, or even I see frequently a sliding scale where if the employee leaves within, let's say, 6 months, they have to pay 100% of the training. If they leave more than 6 months but less than a year, it's 50%. If it's more than 1 year and less than 2 years, it's 25% of the training. Those agreements are still okay as long as the employee is not being required to pay more than the reasonable cost of the training itself. There's some question as to whether non-solicitation clauses could fall under this umbrella of being a de facto non-compete clause. And there's really little guidance in the proposed rule as written. If there's one area where I think there might be room for some expansion by the Federal Trade Commission, it's in this area. But if I were to predict what will happen, in all likelihood, the enforceability of non-solicitation clauses will depend on just how broad they are and whether they are the functional equivalent of a non-compete clause. For example, if the market for your particular industry consists of only 3 or 4 customers, end users, global corporations, and every competitor in the field services those 3 or 4 customers, a non-solicitation clause that prohibits the employee from doing any work with the former employer's customers would probably amount to a de facto non-compete agreement. But if, like probably 95, 99% of businesses in the country, your clientele is varied and competitors don't all service the same small number of customers, a non-solicitation clause will probably be okay. There are some exemptions. In other words, it would be okay to have a non-compete if you are either selling a business. Non-competes are very common in the sale of a business. And in fact, under Florida law, you can get away with a lengthier temporal scope, meaning a lengthier duration of a non-compete when a business is being sold than in your regular, ordinary employment at will situation. There are also some industry-specific exemptions. Those exemptions apply to mainly those in the financial and transportation sectors, but they're listed here: banks, savings and loan institutions, federal credit unions, common carriers. This would be like buses, trains, air carriers, foreign carriers, and then probably one that doesn't apply to anybody here on this call, but you can see who the powerful lobbyists are in Washington still. Persons and businesses subject to the Packer and Stockyards Act of 1921. Again, I doubt that anybody here has employees that fall into that particular area. So that's the Federal Trade Commission's proposal. Remember, that's a rule, that's an administrative matter, not an act of Congress. It does not necessarily carry the weight of an act of Congress, to which the courts typically defer when it comes to policy-making decisions. We've seen very recently, within the last week, administrative agencies' rulings being overturned by courts for exceeding their administrative authority. And I would not be surprised if that final rule, once it is promulgated, is the subject of a lot of litigation over whether or not the Federal Trade Commission has the authority to come up with rulings on contract law, which is something typically reserved for state law rather than federal. On the other hand, if Congress were to pass the Workforce Mobility Act, things would be a little different. An act of Congress has a higher level of deference paid to it than an administrative ruling. And what I think is notable about the Workforce Mobility Act is that it has been introduced a couple of times, in Congress. And each time it has been sponsored by both Republicans and Democrats. In fact, I think that one of our senators, Florida Senator Marco Rubio, previously was the sponsor in 2019 and possibly in 2021 as well. He's actually not this time, although I think he's still in support of the act itself. But what would that act provide? It would provide that with certain limited exceptions, no person shall enter into, enforce, or attempt to enforce a non-compete agreement with any individual who's employed by or performs work under contract with such person with respect to the activities of such person in or affecting commerce. Such agreements will have no force or effect. So in other words, a blanket prohibition on non-compete agreements. There are some exceptions under this act as well, and really the exceptions are limited to the dissolution of a partnership or the sale of a business. Again, the law has traditionally recognized a heightened legal interest in enforcing non-competes pursuant to the sale of a business or that are made in connection with selling a business. Additionally, the act would provide enforcement authority to both the Federal Trade Commission and the Department of Labor, and provide a private right of action in federal court. So what does that mean if this law were actually to go through and we're trying to enforce unlawful non-compete agreements? Well, there are 3 forums in which we could be sued or audited: the FTC, the DOL, and federal court, being sued by the worker, him or herself. What I am a bit concerned about here for those of us on the call is this Department of Labor enforcement mechanism, because if you've been through a Department of Labor investigation, you know that they leave no stone unturned. They might be there investigating a minimum wage violation complaint, but they're going to look at your FMLA policy. They want to make sure that you have the correct policy in the handbook. They want to look at the posters on the wall. They'll audit you not only for that minimum wage allegation, but also overtime. They want to make sure that you are classifying exempt employees correctly and you're not misclassifying anybody as a exempt that shouldn't be, or as an independent contractor who shouldn't be. And now they'll be taking a look at non-compete agreements. So it's not outside the realm of possibility that the very first notice you receive from the Department of Labor is going to ask not only for all of the things I previously described, but also personnel files and any agreements that you've entered into with employees. So I would just be mindful on that and monitor, and we'll see what happens. Like the Federal Trade Commission's proposed rule, this act would require employers to make employees aware of the limitation on non-competes. The Department of Labor also could make public comments regarding the non-enforceability of non-compete as well. The Federal Trade Commission and Department of Labor would report back to Congress on any enforcement actions that are taken. Those are public records, of course, so be mindful that if you're attempting to enforce an unlawful non-compete, you will end up out in the public online community in one of those reports. The main difference between the FTC proposed rule and the proposed act, in addition to there being fewer exceptions in the act, is that the act would apply prospectively only, meaning it would not invalidate non-compete agreements that were entered into prior to the act being signed into law. And that is a fairly major difference because non-compete agreements don't have a shelf life. There's not necessarily an expiration date if the employee continues to work for the employer for 20 years and then goes off and joins a competitor. Well, that non-compete signed 20 years ago probably says something along the lines of, while I'm employed and for 2 years thereafter, I will not go work for a competitor. And, I've seen courts enforce those older agreements. I would not be surprised if employers kind of make a rush to have employees sign off on non-compete agreements prior to an enactment date, if in fact it's this act that passes rather than the FTC's rule. We talked about how the FTC rule would prohibit de facto non-compete agreements disguised as non-disclosures or sometimes non-solicitations. The act here would specifically allow for non-disclosure agreements to protect trade secrets, but it would require employers to post notice of the provisions of the act to its employees. So in other words, on that 6-in-1 poster hanging in the break room, there will be a list of instances where non-competes are unenforceable and the limited exceptions that would allow them to be enforceable. All right. If anybody has questions on non-competes, feel free to go ahead and type them in. I'm aware that, of course, not everybody uses non-competes, and up until now, you're probably wondering, when are we getting to the next topic? The answer is right now. One of the last acts of the previous Congress that went through was signed into law back in December of 2022. This law is called the Speak Out Act, and it pertains to non-disclosure and non-disparagement agreements in sexual harassment or even sexual assault cases. I'm going to limit my discussion to sexual harassment because that's likely the more common scenario that we might face in our respective workplaces. And how might this situation arise where the Speak Out Act will require us to change the way we've done business? Well, for example, let's say an employee raises a complaint of sexual harassment. As part of that investigation and discussion, the parties agree to mutually part ways, and the employer agrees to provide some sort of severance payment or other consideration to the employee, and in exchange obtains a general release that contains a non-disclosure provision. I'm not going to discuss the facts that led to this agreement being entered into. I'm not going to discuss the existence of this agreement. Or a non-disparagement clause, such as employee promises not to disparage employer or any of its employees, whether it's mutual or not. This law, the Speak Out Act, prohibits non-disclosure and non-disparagement clauses that are agreed to prior to when a dispute arises over sexual harassment or sexual assault. And where this leaves many of us scratching our heads is, well, when does a dispute arise? If you were to read the language of the act, the implication is that a dispute arises when there's some sort of formal filing of a claim with a body with jurisdiction to adjudicate such a claim. What's unclear is whether that means EEOC charges fit the bill, or does a dispute not arise until there's actually a sexual harassment case pending in state or federal court? If the latter, I think it will become more problematic to resolve sexual harassment cases prior to them being filed in court, because the employer wants those two things. They want that confidentiality, they want the non-disparagement clause, and they probably aren't going to be willing to settle if those clauses aren't permitted. So if at the EEOC stage, they're not permitted to get those two provisions in an agreement, they have little incentive to settle. And likewise, an employee has little incentive to take a lesser amount of consideration because they cannot provide a non-disclosure or non-disparagement clause. So the advice that I would give here is to stay tuned. Number one, I expect there will probably be federal regulations promulgated interpreting this in the not too distant future, not immediately, but perhaps by the next time we meet, we'll have a bit more clarity as to when does a dispute arise, when can you include a non-disclosure or non-disparagement agreement in a settlement agreement regarding sexual harassment. But until then, we should be mindful that this act is out there. This one has passed Congress. This has been signed into law. There are instances where we are not permitted to seek a non-disclosure or non-disparagement clause to resolve a sexual harassment allegation. And then to recap, I believe we did talk about this last time, but it's a related law that went into effect within the last year or so. This was signed into law on March 3rd. It's titled the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act. And just to briefly recap what this particular law requires, it basically prohibits mandatory arbitration of sexual harassment disputes. If there is an arbitration agreement in place to arbitrate any and all disputes, it is at the employee's election as to whether or not to arbitrate or to go to court. And most employees would rather go to court than in front of an arbitrator for many reasons. Not least among them is that an employee's likelihood of prevailing in arbitration is significantly lower than of prevailing in front of a jury in a jury trial. But another reason has to do with cost. If you were to arbitrate a claim, then most, not all, but most arbitration agreements require some sort of fee splitting arrangement, maybe not 50-50, but the employee has to pay something to cover the arbitrator's cost. An arbitrator is usually a retired judge, a experienced lawyer, although sometimes lay people can be arbitrators as well. They typically charge anywhere from $500 to $800 per hour or more. And the meter is running. Every time that arbitrator is looking at a piece of paper, there's going to be an invoice generated at the end of the month. And the employee and the employer typically split the cost of doing so. So anyway, this is again, just a reminder, if you have arbitration agreements, they may not apply to sexual harassment claims. In fact, I had a lot of clients over the last year update their arbitration agreements to specifically exclude sexual harassment claims or to make it clear that it is the employee's choice as to whether to arbitrate sexual harassment claims. As of right now, all other claims are fair game to be subject to arbitration. It is not unlawful to have an agreement saying that all claims must go to arbitration. It is illegal, however, to try to force an employee to arbitrate their sexual harassment claim. Bear with me while I take a sip of water here and clear my throat. We are moving into the next subject of federal legislation here. And before I put the slide up, let me tell you how we got to where we are. The next slide is going to pertain to an amendment to the Pregnancy Discrimination Act called the Pregnant Workers Fairness Act. And to describe how we got to where we are now, let me just very briefly go over a history of the Pregnancy Discrimination Act and what I'll call the big three U.S. Supreme Court cases pertaining to pregnancy discrimination. Back in 1976, the U.S. Supreme Court decided a case called General Electric versus Gilbert. In that case, General Electric had a practice of excluding pregnant employees from its temporary disability benefits program, what we would think of as a short-term disability plan today, self-insured. The court, 1976, says that excluding pregnant employees, but including anybody else with a temporary disability, is not against the law. It does not amount to discrimination based on sex, which was at the time and still is prohibited by Title VII of the Civil Rights Act of 1964. Congress, in reaction to that in the mid-1970s, passed the Pregnancy Discrimination Act as an amendment to Title VII. And the Pregnancy Discrimination Act made two things clear. One was that the words in Title VII on the basis of sex included discrimination on the basis of pregnancy, childbirth, or related medical conditions. The Act also clarified that women affected by pregnancy, childbirth, and related medical conditions shall be treated the same for all employment-related purposes as other persons not so affected, but similar in their ability or inability to work. So in other words, a pregnant employee could point to non-pregnant employees as a comparator in a discrimination case. And that led to, a fair amount of litigation in the lower courts over accommodations that needed to be provided to pregnant employees, whether they must give them most favored nation status or something less than that, etc. In 1991, the U.S. Supreme Court decided the second in the big three of the cases here, United Auto Workers versus Johnson Controls. Johnson Controls was in the business of manufacturing batteries, which at the time was a very hazardous occupation. Employees would be exposed to lead, which now we know is a highly toxic chemical very dangerous to work around, particularly back in the 70s, 80s, up to the early 90s. Johnson Controls implemented a work rule that they styled as a fetal protection policy. Under this policy, women of childbearing age were prohibited from working in the battery manufacturing process, even if they affirmatively wished to assume any risk, just like the male employees could. Nobody was forced to manufacture the batteries, but male employees, regardless of age, could voluntarily do so. Women of childbearing age were prohibited. This case went to the Supreme Court, and the Supreme Court ruled in favor of the pregnant employees, well, actually the union that was representing them, saying this policy violates the Pregnancy Discrimination Act. And what I highlight from this case is not only is that a commonsensical ruling, in light of the Pregnancy Discrimination Act, don't discriminate against pregnant employees or even employees who are not pregnant but capable of becoming so, but also because this case tangentially touched upon the accommodation issue. The employer, Johnson Controls, was pitching its policy as basically a forced accommodation. And those of us that have dealt with disability accommodation requests are familiar with the concept that an employee with a disability is entitled to a reasonable accommodation that will enable him or her to perform the essential functions of the job. The employee is not, however, entitled to the accommodation of their choice. An employer meets their legal burden simply by providing an accommodation, even if it's not the one the employee wants. And many times, an employee will ask for some sort of restricted or light duty that the employer, for whatever reason, can't provide. Either they don't have that work available, or the limitations are such that they just can't, have somebody doing what the employee wishes to do. The employer then says, well, we can't do that, but here's the accommodation we'll give you. We'll provide you with a leave of absence until your condition improves to the point where you can perform your normal work, or till you can perform light duty that we actually have available. And this approach is perfectly fine. It's the forced accommodation scenario there. Well, in this case, though, the employer was not allowed to unilaterally impose the accommodation on the pregnant or potentially pregnant employees. Just keep that in the back of your mind when we get to the Pregnant Workers Fairness Act, because the Congress and President have signaled that they are addressing one of the highlights of that ruling. The third case is far more recent. In 2015, the U.S. Supreme Court decided a case called Young versus UPS. Yes, that very same UPS that drives around in the brown trucks. What was the issue there? The pregnant employee requested light duty, and the employer, UPS, declined to provide it. UPS at the time had a policy that said, if you were injured on the job, we'll provide light duty to you. Basically, if you have a workers' comp claim, we'll give you light duty. That, makes it such that the employee doesn't collect indemnity benefits, the employer's workers' comp premiums don't go up, and everybody seems happy with that scenario. The policy was also that if you suffered an off-the-job injury, you are not entitled to light duty. You can sit at home, you don't have a workers' comp claim, so you're not getting indemnity benefits. It's really no cost to UPS. So Young files the lawsuit. It goes up to the U.S. Supreme Court. Young's position, which was the position of some of the lower courts and the EEOC, was that if you provide an accommodation to any employee, any non-pregnant employee, you have to provide that accommodation to the pregnant employee as well. Otherwise, that amounts to pregnancy discrimination. If you've ever been in a labor law setting, you're familiar with the term most favored nation status. That's essentially what Young was arguing. The EEOC also actually updated their enforcement guidance while this case was working its way through the courts to make it clear that the EEOC's position was that a pregnant employee is entitled to most favored nation status. UPS, on the other hand, said, whoa, 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 whoa. This is a discrimination case. to prevail in a discrimination case, one of the things an employee has to prove is that they're being treated less favorably than similarly situated employees outside their protected class. So in other words, non-pregnant employees who are similarly situated. She, Young, is not similarly situated. So the argument went, she did not suffer an on-the-job injury. She's being treated the same as all others who have non-workers' comp injuries or off-the-job injuries or limitations. The court rejected UPS's argument and said, no, that goes against the rationale behind the Pregnancy Discrimination Act. It goes against congressional intent, which, remember, was to overturn a U.S. Supreme Court case in the first place. The traditional analysis applies here. For those that have been through a discrimination case, you'll recall that here's how the legal framework operates. Number one, the employee has to come up with some evidence that there's been discrimination. They've been treated less favorably than that similarly situated employee. The employer then has the burden of articulating a legitimate, non-discriminatory reason for whatever the policy is or whatever action it took that's being challenged. And then finally, the employee has to rebut that legitimate reason with evidence of pretext, evidence of a cover-up. Hey, that's not the real reason, it's a cover-up for discrimination. The Supreme Court in Young versus UPS said that evidence of pretext can include that the employer provides this accommodation to others, even if not perfectly similarly situated. So the Supreme Court kind of split the difference, went down the middle. Neither side really got the exact ruling that they wanted, but nonetheless, Young ended up prevailing in her particular case there. So now, finally, we get to the Pregnant Workers Fairness Act. This bill has been floating around since 2015 after the Young versus UPS case. It is designed to clarify what accommodations an employer is required to give to an employee who is pregnant. And the law was actually signed by President Biden. Its effective date is later this summer, June 27th of 2023. The law applies to employers with at least 15 employees. So if you're covered by Title VII, if you're covered by the Pregnancy Discrimination Act, you are also covered by the Pregnant Workers Fairness Act. The law requires covered employers to provide reasonable accommodations to a worker's known limitations related to pregnancy, childbirth, or related medical conditions. As in the world of disability accommodation, and as in the world of religion-based accommodations, it is a defense that the proposed accommodation would amount to an undue hardship. Now, without getting into the weeds on undue hardship defenses, it's worth noting that there is a different standard under disability law than religion-based accommodation law for what constitutes an undue hardship. It is more difficult for an employer to show an undue hardship in the realm of disability accommodations than it is in the realm of religion-based accommodations. I have heard it suggested that the intent behind the undue hardship defense for pregnancy is going to mirror the standard for disability, which is, for example, that a mere monetary cost to the employer is not enough to make an accommodation an undue hardship, other than in rather drastic circumstances. It is not enough to consider the collective effect. If I had to give this accommodation to everybody, it would be an undue hardship. So some examples that are included within the Act as to what amounts to reasonable accommodations for pregnant employees would be allowing the worker to sit or drink water, to receive closer parking, to have flexible hours, to receive appropriately sized uniforms and safety apparel, to receive additional break time, to use the bathroom, to eat, to rest, to take leave or time off, to recover from childbirth, and to be excused from strenuous activities and or activities that involve exposure to compounds not safe for pregnancy. That last one kind of sounds like Johnson Controls, right? The lead batteries, the manufacturing process. But here is where the Pregnant Workers Fairness Act goes against what Johnson Controls was trying to do. Covered employers cannot require an employee to accept an accommodation without a discussion about the accommodation between the worker and the employer. So let me go to the last screen here. Although an employee has the right to be excused from strenuous activities or exposure, that doesn't give employers the ability to unilaterally impose that quote unquote accommodation. It would have to be something that the employee agrees to. Additionally, the Act prohibits employers from denying a job or other employment opportunities to a qualified employee or applicant based on the person's need for a reasonable accommodation due to pregnancy, childbirth, or related medical condition. Covered employers cannot require an employee to take leave if another reasonable accommodation can be provided that would let the employee keep working. Again, difference between the ADA and the Pregnant Workers Fairness Act here. Actually, the standard is a little higher. It's a little more pro-employee under the Pregnant Workers Fairness Act. And then likewise, these are probably common sense, but employers can't retaliate against an individual for saying, hey, the law gives me the right to do this. And likewise, the employer can't interfere with an individual's right under the Pregnant Workers Fairness Act. The damages scheme is more like the Title VII damages, which might include things like back pay, front pay, reinstatement, compensatory damages, attorney's fees, punitive damages, than like the FMLA, which is simply lost wages times 2. You know, you get the lost wages and you get what they call liquidated damages in an amount equal to the lost wages and benefits, I should point out, not simply the wages there. So there's the summary of the Pregnant Workers Fairness Act. Be mindful it goes into effect June 27th. The EEOC is already updating its materials. You'll probably see an email blast from Myra or myself when we do have some regulations that are promulgated here. The EEOC will begin accepting charges on June 27th, 2023. So they're already gearing up for that. Let's shift gears and talk about Florida and Florida's legislative update. I mentioned that the last time we talked, we had a few employment-related acts to discuss. This go round, a little different. There was a law that went into effect last week that may have some implications on workplace policies, although it's not entirely clear at the moment whether that's the case. Let me tee up this issue. Back in 2008, Florida passed a law called the Preservation and Protection of the Right to Keep and Bear Arms in Motor Vehicle Act of 2008. Pejoratively, or maybe not pejoratively, but as shorthand, this was known as the Bring Your Gun to Work law. And under this law, employees who possessed concealed carry permits could keep firearms locked in or locked to their motor vehicle, even on an employer's private property. This extended to parking lots. It did not allow employees to bring guns into the workplace. It did not allow them to fire or discharge firearms. And there were a number of exemptions there. This did not apply, meaning you could not bring your gun to work if you worked at a school, a correctional institution, at a national defense or aerospace or a homeland security operation, or properties that manufacture, use, store, or transport combustible or explosive materials, which actually turned out to be a fairly large exemption there, as it applied to, let's say, auto repair stores that housed batteries, or places that housed fireworks, etc. And kind of ironically enough, I threw this on the slide just because it reminded me that, wow, 2008 times have changed. This was signed into law by then Governor, then Republican Charlie Crist, who of course is the most recent Democratic candidate for governor in the last election. And I don't know whether he would sign that bill into law today. But nonetheless, the law is what it is. It's been around for many years. Most employers adapted to this law by having a handbook policy that said something along the lines of, employees are not permitted to have weapons of any kind on employers' property, including in the parking lot, except as specifically permitted by law. And, you know, over time, I think that most employees, certainly the ones without concealed weapons permits, kind of forgot about this law and didn't really know exactly when they were allowed and weren't allowed to be keeping firearms in their vehicle. The law did have a couple of caveats. Number one was that although only employees who had concealed carry permits were allowed to store weapons in their vehicles. Employers were not permitted to ask whether employees had a concealed carry permit, nor could they ask to see them, nor could they ask to search somebody's vehicle regardless of whether they had a permit or not. Well, why am I talking about this? It's because last week, fast forward to April 2023, Florida signed into law the concealed carry bill, which does away with the requirement to have a license or a permit to carry a concealed weapon. The law goes into effect July 1st of 2023. And the question for us workplace lawyers is, well, hey, does this affect the bring your gun to work law? In other words, does this mean that now anybody can keep a weapon in their vehicle in the parking lot? What rights do I have as a private employer here to prohibit somebody from bringing a gun onto my property? If they can carry a concealed weapon without a permit in public, does that mean that they can bring that onto my private property? And the answer as of now appears to be no. The law doesn't explicitly address whether there's any impact whatsoever on the bring your gun to work law. And in fact, the new law, the new concealed carry law, doesn't do away with Florida's concealed carry permits or amend the bring your gun to work law. So in other words, you could still pay the money, take the class, get a concealed weapons permit. Why might you do so? The answer, I think, would be, well, other states have reciprocity with Florida. If you have a permit here, you can carry there. And likewise, if you have a permit there, you can carry in Florida. The other reason, though, that somebody might have one is because if they wish to keep a firearm locked in their vehicle, as of right now, it still appears to be the law that you would need to have a concealed carry permit to do so on private property. So the takeaway from this is, hey, until further notice, and things could change, employees must still have a concealed carry permit to be locking firearms in their vehicle. So in other words, don't fire somebody for bringing a gun to work as long as it's kept in their vehicle, and hopefully they tell you that they have a concealed carry permit. But likewise, remember, you're not allowed to ask whether they have one or not. Let me talk about some other state legislative updates. From time to time, we do talk about what's going on in other states if there's an impact on Florida employers. This year, there happens to be one pertaining to salary and pay transparency. And this was a fairly hot topic in the news toward the end of last year and early this year when many salary and pay transparency laws went into effect. There are numerous jurisdictions outside Florida. I'm not aware of any within Florida with these salary and pay transparency requirements. But for example, in New York City, in Westchester County, New York, which is adjacent to New York City, in the state of California, in the state of Washington, and in the state of Colorado, there are salary and pay transparency ordinances and laws that employers must comply with. Generally speaking, the purpose and the requirements of these laws is that an employer, when advertising a position, has to disclose what it reasonably expects the potential range of compensation and benefits for the position to be. There are really no fine line rules as to, well, how precise does it have to be? How large can the window be? In other words, 75,000 to 125,000 is probably okay in many of these jurisdictions. 50,000 to 350,000, probably not. There's a reasonableness standard that most employers would have to comply with. Additionally, the general purpose and requirements are to prohibit an employer from asking what was your salary at your previous job and then basing their offer on that number. Oh, good news, we'll give you $1,000 raise from your last job, but we're still going to pay you way less than what we would have paid had we not known what it was that you were making. So why are we talking about this? We're in Florida. We don't have to worry. Well, the answer is if you are advertising for a job that's located in one of those jurisdictions, be mindful you will need to comply with the law. If the position is based in New York City, even though the company is based here in Florida, we need to comply with the New York City requirements. In Colorado, there are even more onerous requirements, at least in terms of when the law applies. First and foremost, the Colorado law applies to any employer that has even one employee in Colorado, including a remote worker. And once the act applies, once you have one person working in Colorado, you must comply with the Colorado law's requirements when advertising for any position that's either located in Colorado or that could be performed remotely. Meaning if somebody decides, hey, great, I get to work from home, I'm moving to Vail, Colorado, I'm moving to Aspen. If in theory the job could be performed remotely within Colorado, you have to comply with this law when you advertise the positions, even if your intention is that, well, I didn't really intend for anybody to be working in Colorado. If they're working remotely, I'm assuming it's from Oviedo. Colorado's law still applies. The other laws, New York City, Westchester County, California, Washington, do not include such a provision. So if you advertise a position that must either be filled or worked at in an office in Orlando or generically remotely, you don't have to comply with the New York City, the Westchester County, the California, the Washington law. You do have to comply with the Colorado law if you have at least one other employee already working in Colorado. All right, let's shift gears. I mentioned at the beginning of the presentation that the way employment laws change might be through an act of Congress or an act of the legislature, but that's not the only way. Executive agencies that are tasked to enforce and investigate violations of certain laws also will come out either with enforcement guidance or new regulations, or as is the case with the NLRB, which acts as a de facto traffic cop, judge, and jury. They come out with their own case rulings. The NLRB is a quasi-judicial body made up of administrative law judges and ultimately overseen by a 5-member panel in Washington, D.C. That's the board itself. But the NLRB as an agency is actually quite huge. And if you're accused of a labor law violation, that's where you will find yourself. First in an investigation that looks an awful lot like an EEOC investigation. But then if you refuse to comply with what the NLRB rules, such as, you need to pay a fine, you need to reinstate the employee, you end up going before an administrative law judge. And on the other side of the courtroom is going to be the NLRB. So the NLRB's prosecutors are arguing to the NLRB's judges as to why the employer should be held to whatever standard the NLRB was looking for in the first place. The EEOC and the Wage and Hour Division are a little different. If you've been through an EEOC investigation, the process is pretty straightforward. You receive a notice that somebody's filed a charge of discrimination or retaliation. You provide a written statement to the EEOC explaining your side of the story. More often than not, the EEOC just closes out its investigation without coming to any conclusion whatsoever. But every now and then they find cause to believe that discrimination or retaliation has occurred. And in those situations, if the employer refuses to go along with whatever the EEOC is looking for, you don't end up in front of an EEOC judge. Rather, what happens is the EEOC will do one of two things. It will either tell the employee, hey, we found in your favor, but this is the end of the line with us. You can go take this case to federal or state court. Feel free to sue the employer yourself. Or option number two is the EEOC could bring a case in court on behalf of the aggrieved plaintiff, meaning the person that filed the charge, or anybody else who has similarly been discriminated against. But at least you're in front of an independent jurisdictional body. You're in a federal court at that point where the judges are not EEOC employees. Rather, they're the same judges that hear federal criminal cases, federal civil cases. They also hear these EEOC cases. The Department of Labor, and specifically their Wage and Hour Division, very similar to the EEOC. If you go through an audit with the Wage and Hour Division and they find that you should have paid overtime to somebody and you refuse to pay it, you don't go back in front of a Department of Labor judge. rather the Department of Labor's Solicitor General can bring a case against you in federal court. But again, you're in front of the federal judge. It's not like a Department of Labor employee. So where does that lead us? Well, we start off with the NLRB. Remember, the NLRB's judges are the ones deciding these NLRB cases. And the first one that we'll talk about today is called McLaren-Macomb. That was the employer. This case was decided in February of this year. And it pertains to, hey, a topic that we've actually already talked about today, confidentiality, i.e. non-disclosure, and non-solicitation provisions in severance agreements. What happened in this particular case is that the employer permanently furloughed 11 employees and presented them with a severance agreement, waiver, and release. And if anybody's ever been through a group reduction in force, you know the drill. You know that these have to include certain additional language pursuant to the Older Workers Benefits Protection Act if you have employees over the age of 40 who are signing off on them. You have to give employees 45 days to consider whether to sign rather than 21. You have to provide them with an explicit statement reminding them they're waiving their rights under the Age Discrimination in Employment Act and that they are advised to consult with an attorney before doing so. And then, although not required by any law, most of these severance agreements are going to include a confidentiality or non-disclosure provision, as well as, a non-solicitation. Hey, you're not going to go pick off our employees, or a non-disparagement agreement. We're not going to disparage or harm the image of the employer, right? Not out of the ordinary. I think everybody would agree here. But here's what the NLRB said. It said that two provisions, the confidentiality, and it was actually the non-disparagement provisions, were unlawful because they violated Section 7 and Section 8A of the NLRA. And their rationale was that those provisions interfered with, restrained, or coerced employees' exercise of Section 7 rights. What does Section 7 provide for? The shorthand is it allows employees to engage in protected, concerted activities. Brad, who's on this call, and I have a running bet as to the over-under when I will first mention protected, concerted activities in these presentations, and the winning answer is 1 hour and 2 minutes. But the NLRB determined that because the agreement conditioned employees' receipt of severance benefits on the employee having to accept these unlawful provisions, the mere proffer of the agreement, merely presenting it to the employees, violated Section 8A1. And I'll briefly tell you what those two sections mean. Section 7 guarantees employees the right to self-organization, to form, to join, or to assist labor unions, or to bargain collectively through representatives of their own choosing, as well as to engage in other concerted activities for the purpose of collective bargaining or other mutual aid or protection. Here's the NLRB's rationale. If you are being told you can't talk about the facts that led up to you signing this agreement, the employer is prohibiting you from getting together with other employees and saying, hey, maybe this isn't fair. Maybe they're singling us out because of fill in the blank. We should take action. We ought to ask for more money. Those things employees have the right to do. And the NLRB said that the non-disclosure, the confidentiality provision, prohibited them from doing so. And then Section 8A1, just so you know, it makes it an unfair labor practice for an employer to interfere with or restrain or coerce employees in the exercise of rights guaranteed in Section 7 of the Act. Interestingly enough, there were two NLRB cases during the Trump administration that specifically found that these provisions in severance agreements were perfectly lawful. So you as an employer may have been following the law, and then all of a sudden in February, this case comes out that says, no, you can no longer have the non-disparagement and the confidentiality provision. What's left unclear is whether this applies only to severance agreements or might it apply to pre-litigation agreements? Remember, I mentioned the sexual harassment complaint that was lodged internally, and the employer came to an agreement with the employee to part ways and the employer would pay money to the plaintiff there. Well, we know in the sexual harassment context, we can't have that confidentiality provision. But what if it wasn't sexual harassment? What if it was, I don't know, the boss just doesn't get along with the employee, and so we decide to pay some money to have the employee leave? Does this apply to post-litigation settlement agreements? Most employers who are settling formal litigation will demand confidentiality and sometimes non-disparagement as well. The one thing that I would remind everybody of is Section 7 rights apply only to sub-supervisory level employees. If these employees had been managers or supervisors, there would be no problem having a confidentiality or a non-disparagement provision in those agreements. Only sub-supervisory employees enjoy Section 7 rights. Now, as a practical matter, I've encountered this situation a few times since the case came out, and I generally will have a conversation with the employer saying, this is what the board says now. It isn't what the board has always said. There's a very good chance that a few years from now, if there's a different party in control of the board, right now it's 3-2 Democrats versus Republicans. At some point, it could be 3 Republicans, 2 Democrats. It's likely that this law will change again. I'm not suggesting that you keep any unlawful clauses in here, but if you insist on demanding a confidentiality provision or a non-disparagement provision, there's a chance that the NLRB could say, no, you can't do this. This is a violation of Section 7 of the NLRA. What's the consequence? I mean, the consequence is those 2 provisions in the agreement would be stricken. You'd probably have to post a notice in your workplace saying, oops, our bad, we violated the NLRA. Here's how to contact the board if you think your rights have been violated. It's not as though there are draconian penalties or severe monetary penalties as well. But again, make the informed decision and consider this the information that you need to get there. The NLRB is also, or recently did announce a change to how it evaluates whether a worker is an independent contractor or an employee. And this honestly is a huge issue that I see almost every day. Employers are incentivized to call workers independent contractors for a number of reasons. Chief among them, you don't pay unemployment taxes. You don't have to cover them on your workers' comp policy. You don't have to pay overtime to them under the Fair Labor Standards Act if they are truly independent contractors. With that said, the Department of Labor and the IRS and state taxing authorities have memoranda of understandings, MOUs, between them in which they agree that they will report independent contractor violations to each of the other one. So in other words, if the Department of Labor comes in and says, ooh, you're calling this person an independent contractor? I don't think so. Department of Labor is going to call the IRS. The IRS is going to say, have you been withholding the employee's share of Medicare, Medicaid, FICA, Social Security? No? Well, that's a violation of the Internal Revenue Code. State of Florida is going to say, you've not been paying into the unemployment comp system? That's a violation of state law. So the stakes are rather high in getting it wrong. Traditionally, the NLRB used a 6-factor test to determine whether or not a worker was an independent contractor or employee. By the way, this is the same 6-factor test that the 11th Circuit, the Federal Circuit Court of Appeals that sits over Florida, Georgia, and Alabama, uses. So whether you're in front of the NLRB, whether you're in front of the DOL, whether you're in front of a court here in Florida, these are the 6 factors used historically by the NLRB. I'll tell you about the change here in a second. The 6 factors include the extent to which the work performed is an integral part of the employer's business. So in other words, if you're in the business of manufacturing widgets and you have a quote unquote independent contractor on the widget manufacturing line, that person's an employee. They're performing work that's integral to your business. On the other hand, if you own a factory and you are repaving the employee parking lot and you hire somebody to come in and bring their own equipment and tear up the old parking lot and put a new one down, Well, that's not an integral part. That's, I mean, certainly ancillary to creating the widgets. You need somewhere for the employees to park, but that's not affecting the bottom line, at least not directly. It's not an integral part of the business. Number two is whether the worker's managerial skills or entrepreneurial skills affect his or her opportunity for profit or loss. Number three, the courts and the NLRB would look at the relative investments in facilities and equipment by the worker and the employer. Again, factory worker on the line, they're making no investment in facilities and equipment. The contractor that's tearing up the parking lot, they're providing the backhoe, they're providing the rollers, the pavement machines, etc. Number four, the board and the courts would look at the worker's skill and initiative. The more skilled a worker is, or the more that the work requires skill, the more likely they are an independent contractor. The permanency of the worker's relationship with the employer. Independent contractors should be short-term gigs, not lengthy permanent gigs. And then finally, but perhaps most importantly, the nature and degree of control by the employer. Under the Trump administration, literally in the last days of the Trump administration, the NLRB issued a directive under which it reduced the number of primary factors that it would consider when deciding if somebody was an independent contractor or an employee. The two most important factors were the nature and degree of control that the employer exercises over the work, and number two, the worker's opportunity for profit or loss based on initiative or investment. And only if those two factors don't point to the same conclusion would the NLRB then go to the other factors. The main goal, of course, under this interpretation is to make it easier for employers to show that the workers are independent contractors rather than employees. Well, back in October of this year, under the Biden administration, the NLRB reverted back to the 6-factor test, which, just so you know, is frequently called the economic reality test or the totality of the circumstances test. And in fact, it gave some clarifications regarding some common scenarios. For example, when it comes to that factor about the integral part of the business, if the employer could function without the service performed by the workers, they look like independent contractors. If they could not function without that service, they look like employees. The managerial skills is still a factor. The relative investments is a factor. The NLRB clarified that an employee or a worker who uses a personal vehicle to perform the work is not making an investment in capital or that's entrepreneurial in nature. So in other words, if you operated a small size version of Uber and your workers have to drive their own cars, that's not enough to show that, hey, the workers are investing in their materials to be independent contractors here. I shouldn't even get into Uber because there are a ton of decisions out there that go back and forth all the time about whether their drivers are independent contractors or employees. When it comes to the level of skill or initiative that the job requires, the board has clarified that the work of security guards and janitors, drivers, landscape workers, and call center workers do not require specialized skills. So don't try calling these employees independent contractors. And then finally, when it comes to the nature and degree of control, the board has clarified that an employer cannot claim that control that's required for compliance with legal obligations or safety standards or contractual or customer service standards fit the category here, fit the bill. That tends to make them look more like employees rather than independent contractors. Okay. Wrapping up, I think this is our last topic, agency enforcement priorities for 2023. I mentioned that these are made public. The NLRB, in fact, announced earlier this year about the independent contractor reversion. They have gone ahead and done so here, but other agencies have issued some guidance as well that I thought would be worth conveying on to everybody here, particularly if you're in an industry that is affected or targeted by any of these agencies. The first agency is OSHA, our good friends at the Occupational Safety and Health Administration. I can personally tell you I have handled more OSHA investigations in the last year, year and a half than I did in my first 20 years of practicing labor and employment law. OSHA is very aggressive these days in conducting investigations and in levying fines and penalties. And that's what this first initiative pertains to. Back in January, OSHA issued enforcement guidance that they would treat certain types of violations as what they call instance by instance citations rather than grouping violations into a single citation. And what I mean by that is if an OSHA inspector were to happen to be driving down the street and they see a construction site where new homes are being built and there are 10 people on the roof and none of them have safety equipment on, traditionally OSHA would issue only one citation. These days, though, they will issue 10 citations. 10 people on the roof without safety equipment, that's 10 different citations. The rationale is that the change is intended to ensure OSHA personnel are applying the full authority of the Occupational Safety and Health Act, where increased citations are needed to discourage non-compliance. This went into effect, was this last week or the week before that? March 27th. I mean, this was just within the last couple of weeks that this enforcement guidance has gone into effect. Why is this scary? Why is this something that Keith is telling us about? Well, here's why. Here's what the penalty schedule is for 2023. There are 4 different types of penalties or violations that OSHA could find if they come on site and they do an inspection. The least serious is what they call other than serious violations. That might be, for example, somebody on the ground in a construction zone that doesn't have a hard hat on, but they're not working around tall buildings or things that might reasonably be expected to fall on their head. A serious violation, though, would be that same employee not wearing the hard hat, but working directly below employees on a scaffold and a hammer could fall, or building materials or whatever might fall on them. That's a serious violation. A willful violation is just what it sounds like. There's no safety manager on site. The employer does not distribute safety equipment. Employer doesn't care whether or not the employees are using safety standards or anything like that. And then finally, repeated violations. So a serious or other than serious violation that resurfaces in a subsequent investigation counts as a repeat violation. The first 2, the least serious, and I say least serious, but one of them is called serious, the maximum current penalty is $15,625. For the 2 more serious violations, willful and repeated violations, it's $156,000. And remember, now we're looking at each one of those construction workers without the hard hat or without the safety equipment on the roof being their own citation. So 10 citations now at $15,000 a pop is $150,000. Whereas previously, prior to March 27th, those 10 individuals on the roof would only result in 1 citation, which is a $15,000 penalty. Rather significant change, I would say. And OSHA has announced what industries it is targeting for enforcement. And those industries include general industry, agriculture, maritime, and particularly here in Florida, construction. Like I said, I have seen more in the last year, year and a half than my previous law career representing employers in OSHA matters. So be mindful. OSHA is on the lookout and the fines are certainly steep and increasing. The OFCCP, the Office of Federal Contract Compliance Programs, if you are lucky enough to be a federal contractor or subcontractor, you are probably very familiar with these 5 letters. If you are not, don't worry, that's okay. The OFCCP issued its directive back in late 2022 regarding what they call effective compliance evaluations and enforcement. And the moral of this story here is that things are about to get more difficult or more onerous for those federal contractors and subcontractors who are subject to OFCCP reviews and audits. And I've highlighted what the biggest changes are here. Number 1 is that up until now, if you were going to be audited, you would be advised of such well in advance. You know, it's not as though the OFCCP shows up on your door like the Department of Labor and says, I'm here to take a look at all of your pay records or whatever records OFCCP wants to look at. Rather, they would announce that, hey, 10 days, 7 days, 30 days from now, we're going to be there to conduct our audit. No more advance notice. Number two, you should expect that the OFCCP will request more additional data, that they'll conduct more witness interviews and seek more witness information when they're conducting their audits. And then finally, they are considering adopting a revised compliance review scheduling letter. That's the letter that you get in the mail or dropped off by personnel saying, hey, you're in line for an audit. Here's what we would like you to compile and have ready for us when we get here. The punch list of things that they will be asking for is about to go up, or at least they're considering making that go up. So if you are a federal contractor or subcontractor, hey, is there really anything that you need to do to brace for this? Not necessarily. This is more for awareness, particularly if you've been through one OFCCP audit and thought, well, that wasn't that bad, or hey, I've been through these before, I know what we're doing. Well, things will be a little more intense now if you get audited. Your past experience will not be an accurate predictor of future success necessarily. Well, my friends, I think we might have finished a minute or two early. I don't want to get anybody in trouble here. I won't tell if you won't, but if anybody has any questions, Myra and I will stay online for a bit after if you want to type it in front of everybody, but we'll certainly answer whatever questions that you have. And let me just, thank you and turn it back over to Myra.
Thank you so much, Keith, and thank you everyone for joining. Again, as he mentioned, if you have any questions, please feel free to reach out to anyone on our team or to Keith directly. And just also as a reminder, the seminar was recorded, so we will get that out to you shortly. Thanks and have a great day.